What happens when you are asked a question that you could not or should not answer?
Well, that's entirely up to me to decide whether I should answer a question. For example, in the meeting that we had today, there was a question that related to a particular case that might actually appear before me, and I have to use my judgment to decide whether I should get into detail with it.
We deal with questions we don't feel we can answer in a straightforward fashion. We say, look, I can't answer that.
It's entirely up to me to make that decision, and if I choose not to answer, that people understand that. So I'm not worried that a question might come up that would be inappropriate because I'm in control of saying, well, I don't think I should answer that question.
It's not often during one of these meetings that an attorney will say, hey, Judge, how are you going to rule on that case you heard last week? But you know what? I'm not saying that that's never been asked. People sometimes even ask that. And of course you have to say, look, I appreciate your interest, but it's improper for me to offer a suggestion. One of the reasons why it's improper is if I'm in the course of writing up that decision, my research and my review of the evidence that came in might lead me to change my mind. So I refrain from answering those questions. The more difficult ones are hypotheticals, where someone says, what about this, Judge? If it's a very fact-specific hypothetical within the context of our jurisdiction, someone says, what do you think about stormwater during such a rainy day like this? I'm going to say, look, I'm not sure. I don't feel comfortable answering that question because I think it might come up in a case.
Can you discuss your role as a judge during one of these meetings?
Generally speaking, I will chair the meetings that I'm hosting, but my goal is to have as much discussion as possible among the lawyers and the judge to share thoughts and ideas. And it's a way to have discussions that we can't have in the courtroom when we're there on a particular case. It's a way to talk about broader issues that might involve many cases and to do it in an informal setting.
I view the role of a judge during these meetings first to listen. Keep in mind there's a real concern on my part, on fellow judges' part, to not offer advisory opinions. And there's always, even well-trained and respectful lawyers during these meetings will sometimes ask a judge an opinion of, what do you think about this, Judge? And you've got to be careful to not answer it in a manner that would foreclose your right to conduct a fair hearing on that topic later on.
Yes, sir.
You know, the reality, I think, in litigating cases in the environmental court is that in many cases, the attorney's fee component of the overall cost is a small percentage of that overall cost. And that's because many of these cases, including certainly almost all of the Act 250 cases, are driven by consultants' costs. The cost of a civil engineer, a traffic engineer, a landscape architect, a hydrogeologist, somebody who can provide that testimony to avoid the frustration of meeting with a client who has this need and having to sit there and tell that client, my fees are pro bono, but you need a hydrogeologist or you need a traffic engineer to present your case. I think what needs to happen here, if this is really going to work, is that you need to get not only the lawyers on board, but the engineers on board. You need to go out to the other disciplines and get a pool of those folks who are willing to donate their time. So if we're going to represent these people in a meaningful way in these proceedings, in a way that we can be successful on their behalf, which is in essence our ethical obligation, we're going to need those resources as well.
I don't disagree. I'll talk to my boss about expanding the scope of my job. But you're absolutely right. Sometimes the lawyer in place can pick up the phone and call. If that lawyer is donating his or her time, that's a pretty effective contact to make to colleagues in the field, the hydrogeologist, the surveyor, to ask for free representation from them as well. Sorry, Judge.
Oh, no, I was just gonna say I agree with Dan. And I can think of a couple of cases recently that would offer specific examples. But I think from the perspective of the program that Mary has just gotten off the ground and coordinated this seminar for in the fall, let's walk before we run. I mean, I see the need a lot in the simple case where someone has filed an appeal of a municipal zoning permit, not because they have a gripe about the permit, but because they've been feuding with their neighbor for the last 25 years because their dog comes to their garden or something like that. Now, we can have a trial about that, I guess, or we could, or it could be handled much more efficiently if an attorney volunteers to have a confidential discussion with that appellant to say, look, let me explain to you what issues you can raise within the environmental court. You know, because oftentimes, particularly in those kind of cases where there's no attorney on either side, applicant or appellant, I'm waiting for the motion for summary judgment to come in, and they go, huh? You know, it's just not even thought about. So the only vehicle I have for resolving this case in that pro se situation is set it for trial.
Yeah, and Dan raises a good point, but I think what we're talking about here are discrete elements of cases like mediation, like counseling up front, or these smaller cases that can more easily be addressed. And then I think as this evolves, Dan's point is a good point. I've had cases where I've taken cases pro bono, and then I've said, but you need somebody really. And maybe they'll do it for half price, and they have, with a call or two. Other cases I've said, you're not going to win, I'm not going to take the case if you can't hire somebody. It doesn't make any sense to go forward because it's going to cost you this much money. Do you want to spend this much money? No, I don't. We don't have a case then.
What is your role as the moderator for this kind of meeting?
Well, I think it's just that. I think it's to bring the members together, make them feel comfortable, make the court feel comfortable, and moderate the topics and let other people lead the substantive discussions, but prompt and facilitate the discussion so that it is more expansive. What I've done personally is I've tried to get different elements of the bar involved in the meetings. Today I succeeded in getting some people from the Enforcement Agency Division and the Agency of Natural Resources to come, and I've been working with the law school to get some of their students to come. And so I've been looking for diverse viewpoints because I didn't want to just have private practitioners. I've been trying to get the nonprofits to participate in the state agencies, and that's hard sometimes because everybody's busy.
How do these meetings help you in your day-to-day work, and how do they improve the effectiveness of the legal profession?
Bench bar meetings are valuable to me as a judge because I can get feedback from attorneys about topics. For example, if we've been having issues in a particular kind of case with scheduling, or there's a new law that might be changing how we're going to address things, it's a way both for me to communicate that kind of thing and to get feedback about it.
I think that the opportunity for these meetings, because there are restrictions in individual cases of how the judges and lawyers interact with one another, it all has to be out on the record and with no private discussions. These meetings are a vehicle for the development of the law. If there are issues that have become a problem over the course of many cases, it's an opportunity to bring up the problem and see whether the committee wants to recommend a change in the rules or a change in the statute that would cure the problem that many practitioners have noticed in a number of cases. And similarly, if the judges have experienced a problem, either a practice problem or even a legal issue that the bar as a whole might want to work on, analyzing and determining if something needs to be changed. This is a vehicle for raising it, for bringing it up.
So you could do some of the same things by sending out, say, a written questionnaire, but it's just more comfortable to have a conversation about it. People are more likely to respond than if they have to write something. And as a judge, we spend most of our time in a very formal setting. We're in the courtroom, on the bench with the black robe on. The lawyers are down there standing in front of us with their clients. It's not a time where you can say, hey, and by the way, what do you think about that new law? And so having a setting where you can have those conversations informally is, for a judge, I think, a real pleasure and very valuable. So the one other thing that I had prepared was just something that I called courtroom tips that I'll pass out in a second, just some comments about suggestions I have for lawyers. But before we do that, because that could go on forever, any other topics that people would like to bring up about what's been going on in this county or statewide legal issues, anything like that? Come on, this is your big chance.
When we were here last time, I asked about something that was new at the time, which was the half-day court closures around the state, and you said that it didn't affect the Superior Court. I was talking to a court clerk, the Superior Court clerk the other day, and I said, well, I know it doesn't affect the Superior Court. And she said, well, it does affect them. So I know now that we've got the 12 days of furlough, and I was wondering if you could comment on the effect. You know, is this now having an effect on Superior Court? What's the impact on access to justice?
The furlough days apply to everybody in the sense. Well, Claire, do you want to come up and comment for a minute as the Superior Court clerk about how the clerks are interpreting all of those things?
Okay. On the half-day closings, I'm not sure who you spoke with, but the Superior Courts that stand alone were not affected by the half-day closing. Superior Courts were there in the building with state courts, did close the half-day. That's that explanation. We will now all be closing a day a month for this fiscal year until next June, and it has affected some of the courts, smaller courts with their backlog. It hadn't affected us yet, but I'm beginning to see the outcome, and I think with 12 days we will definitely see our backlog growing.